Commit to Wealth Nation, welcome to the Commit to Wealth podcast. I am your host, Juan Vargas. Today on the show, we have Juan Trowbridge. Juan is a former commercial real estate broker and successful syndicator. He is now a leading securities attorney and expert and has close to 40 years of experience assisting new and experienced syndicators. He is a CCIM instructor, the author of a very detailed and helpful book called It's a Whole New Business, and the co-founder of Trowbridge Syndicators LLP. Juan, welcome to the show.
Hi, Juan. Thanks for having me. I appreciate it.
Thank you for coming on, and you know, you're going to provide us a lot of value. I know that. So, guys, stay tuned here. So, let's go ahead and get the show started by telling us, your background, and let's kind of go back, to the first, early days as an entrepreneur, and kind of take us from there a little bit, and then we'll fast forward to these days.
All right, Juan. Well, I started as graduated from college, and I started as a commercial real estate broker. And after 4 or 5 years of that, I went off with some of my friends, and we bought our first property, an apartment building, just like everyone else does.
There you go. Yep.
And I kind of liked that. I liked working with the other 3 investors and managing the property for them. So eventually, I gave up being a broker and just went to being a full-time syndicator. 20 years of that, the care and maintenance of partners kind of wore me out. So I thought I'd do something else that was equally as damaging to my psyche, and I went to law school. I went to law school, and I was 45. I had kids, had a job, had a wife, and I went to law school and was sworn in the California bar. And about 5 years after that, I really gave up raising money and starting new deals and went on just to manage the deals I had and head for the practice of law, which I'm doing now. We have a good law firm, Jillian Sidoti. Many of your listeners probably have heard of or seen Jillian.
Yes.
And she and I are out here in Southern California. And it's funny, I met her in a CCIM class many years ago, and now we're partners, and it's great. We do a lot of business all around the country because we do federal offerings and I know we're going to talk about Regulation D. So we do federal offerings, so we can do offerings anywhere, and it's an exciting business.
There you go. Well, I appreciate you giving us a little bit about your background and, telling us, how you even started it. So, that is always good. And I like that you were able to start like in multifamily, and that's kind of our main focus here is multifamily investing and, real estate in general, but multifamily more specifically. So yeah, let's go ahead and get this show started. First of all, I guess, we can start with the nuts and bolts of a security and, deeper than that, what exactly is a security? Tell us a little bit more about that.
All right. One of the questions I get from people, or the most asked questions, is, Juan, I'm going to put 4, 5, 6, 10 people together, and I don't know if it's going to be a syndication or not. And I say, of course it's a syndication. Just simply a syndication is when you have 2 or more people investing together. But the better question is it a security? Because once we determine it's a security, we go into a whole nother set of rules. And so we need to know what a security is. And a security is pretty simple. It's when people invest their money in a common enterprise, like an LLC or a limited partnership or a corporation or a joint venture or a tenants in common, anything like that where they're investing together. And they're investing because they expect to get a profit. This is not a gift. This is an investment looking for a profit. And the results are going to be controlled by someone like you, Juan. If you got 10 people together and you were going to buy an apartment building and you said, I'm going to raise the money, I'm going to make the decisions, I'm going to manage it, well, that's a security. And the most important part of those 4 prongs, an investment of money in a common enterprise with an expectation of profit through the results of the sponsor. That's the most important part. So if you have a managed LLC, it's a security. If you get rid of the manager and you just say the 3 of us are going to do something together and we're going to make all unanimous decisions, well, then it's a member managed LLC. And without a manager, more than likely it's not a security.
Got it. So you have to have the manager in with the expectation that the manager is gonna, do something for you. In this term, or in this case, they're gonna do. They're gonna try to generate some capital for you. And so, what would you say the difference is between maybe that and just a straight partnership where you get 2 or 3 people together and you're all working together as managers. How would you define each one and kind of differentiate it?
We write those type of legal documents also. We put together an LLC, and we would call it, and we would file it as a member-managed LLC. And some states require you to use the word manager-member, but really you aren't. They're all just members, and I'd probably write a document that says all decisions are unanimous, so that no one person has control of the offering. If no matter what you call it, Juan, if you've got control, then it's going to be a security.
Got it. So it would be safe to say as well that in a member managed LLC, we are not using a PPM, in which, that's another term that we'll be getting into here shortly, but we are not going to be using a PPM, or is that necessary? Is that correct?
That's right. If it's member managed, if it's not a security, we don't need to follow any of the securities laws. If it is a security, we need a PPM. Period.
Got it. Okay, well, let's kind of get into the offerings. I know we have, either public offerings or private offerings. Tell us a little bit more about what each one is and who is the ideal, people that would use either one.
Okay. For your audience, if we're going to talk about an offering that is more public than private, we'd be talking about a Regulation A plus offering. I call it a Reggae Offering, which means you have to wear your Rastafarian hat and all that if you're
yeah.
So it's a Reggae Offering, and in our firm, Jillian does most of the work on the Reggae offerings. But what a Regulation A offering would let you do primarily is advertise. You can advertise to anyone. You can take non-accredited investors. We'll talk probably about accredited, sophisticated, and non-accredited investors as we go on. But it's really the only way you can do an offering where you can take people who you don't really have to worry about how much money they have, and you don't have to worry about their education and their experience. It's just simply non-accredited. And you can raise up to $50 million a year in a Regulation A, advertising to anyone, taking non-accredited investors and sophisticated and accredited, no limit number of people you can take, but because you can advertise to the non-accredited investors, it's regulated. The SEC looks at all your documents, and if they pass muster, they will give you a permit to go out and raise money, and then quarterly you do audited financials and submit them to the SEC. So that's a little bit of regulation, but it still doesn't put you on the stock market. It's not like a public offering where you're gonna go on to NASDAQ or something like that. That's totally more complicated than the Regulation A offering.
Got it. So there's Regulation A, and so we have also Regulation D, which is probably the most common one that we are going to be using and we're going to be discussing, right? So I guess, let's go ahead and get into that. What is that, and why is it that we use that mostly?
Sure. The most recent statistics are that the private placement market is $1.6 trillion in 2017. About a third of that is real estate.
Okay.
So it's still, $700 billion.
Billion, yeah. Mm-hmm.
A lot of money.
Right.
And 99% of that money, the whole 1.6 trillion, 99% is raised in Regulation D, Rule 506.
Okay.
So what is Regulation D? It's the ability to do a private placement without any registration with the SEC. We do have to file something called a Form D with the SEC, and that's just an information gathering form that they require you to file. But there's no really regulation. And even more than that, if you're going to do a Regulation D offering, you totally avoid blue sky. So if you do a Regulation D Rule 506 offering, it's exempt from full-blown registration with the SEC, and it's preempted from the state regulators making some opinion on whether you can do it or not. You just go ahead and do it, and you send the state a notice when you raise money from one of their investors. So Regulation D Rule 506 is where we're going to play, Juan.
Got it. So Reg D 506, and so the most common type that, I guess that we can discuss about, because it's going to be the ones that is going to affect us the most, is 506B and 506C. So tell us a little bit more about each one of these and who each one of these is for.
Regulation D Rule 506 has been around a long time, and the basics of that rule are that you can raise as much money as you want in one of those offerings. You can have as many accredited investors as you can get. You can have up to 35 sophisticated investors, which is different than accredited, and you need to give them a PPM, but you cannot advertise. So typically we say a 506B is the offering that we do when we have a pre-existing relationship with our investors. And in our practice, we're still doing at least 8 out of 10 offerings as 506B. And there are a lot of reasons for that. Well, the Jobs Act came along in 2013 and said, why are we limiting advertising? Why are we protecting those accredited investors who by definition are rich and smart? Why are we protecting them? Why don't we just advertise and let them decide if it's an investment they want to make? So they created 506C, which is basically the same as 506B, which is the old rule called 506B. Now the new rule is 506C, and it's everything that I said it was, except you can advertise, unlimited, but any investor you take into your offering, you need as a sponsor to take steps to be reasonably assured that your investor is accredited. And that's really the main difference. Now, as I said, 8 out of 10 people are still staying in 506B, because the problem with advertising is if you don't have a track record, Juan, and you haven't done some deals, just because you can put it on Facebook that you're raising money, it's not an effective way of marketing. You really need to have been in the business, have done some deals. So we're using 506B over and over and over to help our investors, our clients, raise money. And we do small deals. The last deal that was really small, our client raised about $300,000 in a 506B. We're doing large deals. The last really large deal, it was $150 million in a 506B. Okay, so it's all over the board.
Got it. So you mentioned from 300,000 has been one of your smaller ones, and then up to 150 million. So what would you say is the average for you that you work with?
Nationally, since the Jobs Act was passed, there have been 77,000 Reg D offerings, and the median, which means half are bigger and half are smaller, is about $2 million.
Okay.
So the median on the national average is 2 million. The median in our firm is probably 3.5 million. But we do an awful lot of first-time offerings. I'll tell you that when I mentioned the $150 million offering we did that company's first offering, which was $1.5 million.
Wow.
Years later, they're at $150 million.
Yeah, so it's pretty safe to say that they have grown pretty well from just a million, a little over a million to 150. They have gone come a long way. So that is awesome. Tell us, real quickly, also, what is the average cost? Obviously, is going to take a lot of work even for a smaller one, but as you get larger, it's still going to take a lot of work for you guys. And so, what is the average cost on setting up from the actual LLC to the documents, the whole shebang? How much does it cost on average?
Let's say you were going to raise less than 5 million, which is going to cover almost everyone who's listening to us today. I think you should budget $15,000.
Okay.
And if you're going to raise less, maybe it'll be a little bit less, but you shouldn't have to pay more than $15,000 for up to a $5 million raise. Not the price of the property, but the equity raise.
Right. Yeah. Just the equity raise, which is the capital that you're going to be raising. It doesn't take into account, how much the entire purchase price is. So, yeah, that's a great no. So thank you so much for sharing that. So let's talk about, you mentioned earlier that you have, sophisticated and accredited investors. I mean, what is each? What does it mean? For those of us that don't know exactly what that means, tell us a little bit more about that. Kind of go into a little bit more details on that.
Sure. The reason we have these two definitions, accredited and sophisticated, is that the SEC, when they passed the rule way back in 1933, the Securities Act of 33, they said, rich and smart people don't need the protection that the rest of us do. So you're either rich and smart or you're whatever else they are.
All right.
So the rich and smart people, they said, we need to identify that and define that. So really in 1981, they came out with a specific definition. And the definition is still the same today, which was kind of frightening. It is that if your net worth is over $1 million, and you cannot include your primary residence, which was a big change in Dodd-Frank. Dodd-Frank came out and said, let's not let people include their primary residence, which really cost us about half of the accredited investors in the United States when we took out their home. But if you have a net worth of more than $1 million, excluding your primary residence, you're accredited. Or if as an individual taxpayer filing separately, you have annual income, total gross of $200,000 or more, and you've had it for the last couple of years and you think it's going to continue, or if you're married filing jointly, $300,000 or more, then you're accredited based on your income. So it's an either or, it's a net worth measurement or an income measurement. And the SEC simply said, we can't regulate every offering that's out there. And there's really no reason to regulate offerings for people who are rich and smart enough to read the documents themselves, ask the questions, get their answers, and make a self-determination on whether the investment is suitable for them.
Got it. So I want to go a little bit deeper on that on a 506B offering versus a 506C. Well, one of these, we have to self-certify that we are actually accredited. So tell us which one of these it is and why they allowed that in the first place. And on the other, it is for accredited only, which is 506C. And, there's a process that, they have to kind of double check that you are truly accredited. Tell us why that is. Why are we able to, self-certify ourselves and just basically check a box saying that we are accredited?
In 506B, where you generally have a relationship with the investor, they let the investor self-certify, as you said, just by checking a box on the offering questionnaire. For example, if you were doing an offering and you asked me to invest with you, and I did, and I checked the box that I was accredited, ideally you would know enough about me to say, yeah, that makes sense, or no, gee, that's crazy. He couldn't possibly be accredited. Let's go farther into the offering questionnaire and see what the answers to his questions are. and let's see if that's okay. But in 506C, where you're advertising, you don't know the person at all.
Right.
Then they require you to take reasonable steps, and you can take those steps to determine if your investor is accredited. There are basically 4 steps you can do. You can ask them for income tax returns to show their accreditation through income. You can ask them for some sort of a documentation to show their accreditation through net worth. You can ask them to get a letter from their CPA, their registered rep, or their attorney that says that person has looked at their financial statements and has said that they are accredited. Or if they've invested with you before and they've verified that they were accredited and there's no reason that you think their situation would change. However, most syndicators, most sponsors don't do that themselves. Juan, the problem of asking me for my income tax returns is, number one, you're not used to doing that as a sponsor. You may not want to do that. I may not want to give them to you.
Mm-hmm.
But even if I did, now you have to keep those for 7 years. And those are highly confidential, and you have an issue with that. So there's an industry out there that verifies investors for you. And there are several firms out there that do that. Your investor goes to the firm, they go through the question and answer session, and they give you, Juan, the syndicator, a document that says, hey, we've checked Gene out and he is accredited. And so that's the way to do it. It costs $40, $50, takes a day or two. All of my 506C clients use a third-party verification system.
Got it. So yeah, thank you so much for explaining that. So I would say, to summarize on that, the biggest difference is the pre-existing relationship between, the 506B, 506C, and that's why you're able to self-certify on a 506B, and a 506C you have to verify that, or take it to a third party where they can verify for you. So now that we are speaking about, or we made the discussion about pre-existing relationships, what is a pre-existing relationship, and how long do you have to know the person before you can actually bring them into your offering?
Well, the real issue is not to be accused of making an offer through advertising or solicitation. That's really the rule. The rule is no offer can be made through advertising or solicitation. So
Okay.
one of the ways you can defeat a claim that you advertised to me, and that's how, and you made your offer through advertising, is if you have a pre-existing relationship with me. That's one of the methods, and I'll come back to that in a minute. But it's not the only method. You could be sitting on an airplane alongside of me, and we could start talking about what your business is, Juan, and you could find out that I'm interested in investing. And you could talk to me about your investment right then and there. We don't have a pre-existing relationship, but it'd be pretty difficult for someone to say that you advertised to get me on that airplane.
Yes. Mm-hmm.
So I could sit alongside of you and you could talk about that.
Okay.
Or if one of your investors says, hey, Uncle Bob in Idaho would love to hear about this. Well, you really didn't advertise Uncle Bob. So referrals, casual meetings are fine. The number one way to defend yourself is, of course, a pre-existing relation. And I'm going to tell you some things that it's not. Okay?
Okay.
It's not the 3-touch rule. Okay. We have heard about the 3-touch rule. Some gurus out there pitch that. If you talk to your investors 3 times, it's okay. So you go to breakfast with them, you go to lunch with them, and at dinner, you take their money. That's probably not okay.
Okay.
There was a company that asked the SEC for approval to do a solicitation campaign where there were 3 different times and 3 different activities involved in building a pre-existing relationship. And the SEC said in that situation, everything they were doing was fine. But it's not a blanket 3-touch rule. The other one I hear is 30 days. Okay. if you wait 30 days from the time you advertise to someone, you have a pre-existing relationship. Well, no, that's not the law. Once again, there have been several no action letters issued where companies have said, we're going to try to attract people through our website. We're going to give generic information about why it's a good idea to invest in multifamily. People are going to come to us. We're going to get to know a little bit about them, and we're going to put a 30-day cooling off period, if you would, before we actually sell them something. Or we're not going to sell them anything we have offered right now. It'll be some future deal. Those things are okay, but it's very fact specific. So that didn't answer your question. Your question is, what's a pre-existing relationship? And there's no definition. However, if you know enough about Gene Trowbridge to know that my education, because my education, my training, my financial acumen is such that I could probably read these documents and I could make a determination for myself that it's suitable for me, that you know enough about me to say that, and you have had enough conversation with me that you know I have asked you about your business, I have learned about what you're going to do, and you really think, either overtly or subtly, that I'd like to hear about your next offering. I think we have a pre-existing relationship.
Got it. Got it. So there's no set rule per se, but it is safe to kind of to know them, and know their interest and know that they are financially able to, look at these deals and they're financially capable, literally as well. So, that is good that you're able to share that. I want to ask you as well, this is a question I had earlier, but I want to ask you right now is, you mentioned, an accredited investor is somebody that has a net worth of $1 million or more, or their income, their annual income, which is 200 grand or more if they're single, or 300 grand or more if they are married, right? So, but this is all, if you're measuring on the net worth, it is not basing it off your home, it's excluding your home. Tell us a little bit more why we do that, or why that is that they're not excluding, or they're excluding your home, and why you cannot include that.
Sure. Prior to Dodd-Frank changing the rule on being able to include your primary residence, so I live in Southern California. There are retired people who bought houses for $60,000 in the 60s who are living in those houses today. They get a Social Security check. Their house is free and clear, and it's worth well over $1 million. They're accredited, but they need some protection.
Got it. Yeah.
So during the last market crash, a lot of those people lost money that they really couldn't afford to lose. So they just said, let's take the house out of there. And that's really the trend of the conversation at the SEC is, do we need to change the accredited investor definition? You've got to think about 1981, $1 million was $1 million.
Mm-hmm.
Today, maybe that with inflation, that's $2.5 million. The $200,000 maybe today would be $350,000, and they have never adjusted those numbers. Now they are going to, at the minimum, start adjusting those numbers every 5 years for inflation, but that really doesn't to make up for it. So I think that was a good move, especially what I see in some of the high-priced, high appreciation areas in the country, where the people who live in their houses sit on a lot of money and it's their only asset. We probably need to protect them.
Yes. Thank you so much for explaining that, because I know that's a question that a lot of people had, and, they wanted to know why their home was excluded from that. And you gave a good explanation. If you live in a high appreciation area, such as, Southern California, Washington, or New York, or, one of those kind of markets, then it's pretty safe to say that your appreciation is going to go pretty high. And so therefore, your net worth will increase, but, for the sake of doing a proper security, or getting into one of these, private, placements, and then yeah, we're not going to include your home because because of that. So thank you so much for explaining that. I appreciate that very much. So I want to talk about a little bit more on the after it's funded. Let's say we get a deal and it's funded and we're closed, and so we have an investor that needs their funds. They need to be liquid for some reason. What happens there? How do you protect that, or what routes do they have?
Yeah, that's a good question. That's one of the 4 questions that you'll get as a syndicate. I'll go through all 4 of them and I'll talk about that directly.
Okay.
The first question you're going to get, Juan, is, Juan, I'd love to give you my money. It sounds like a good investment, but what happens if something happens to you? So
Okay.
you're going to need to give me an answer that talks about continuity. What have you built in the manager entity that protects me if something happens to you? And not just dying. I have been the replacement manager in 6 deals in my career where something happened to the manager, and there was only one manager, and in only one case had that person died. But the other 5 cases, they were unable to continue. That really caused trouble for the investors. So that's the first question. The second question, Juan, you're going to ask me is, Gene, have you done this before? And we've all had to answer that question. No, I haven't. This is my first time. So we need to get that first deal out of the way. So don't try to raise $20 million in your first deal. Try to make it a small deal, get it closed. So when Juan says, Gene, have you done this before? You could say, hell yes, I have, Even if it's only one, you've done it. That's right.
Yeah, you've done it.
And then the third question, Juan, is, Gene, if this is this good of a deal, are you investing in it? So you're probably going to have to put some skin in the game.
Right. Mm-hmm.
Then the fourth question is the one you asked. Juan, or Gene, if I need my money back, do you have a plan for liquidity? And the answer that you would give is yes, our operating agreement has an extensive plan on liquidity. And so the attorney that you hired is putting a whole section in there on liquidity. And there are a couple ways that you need liquidity. Sometimes it's involuntary. You die, here comes a will, you file bankruptcy, the court wants your assets. And so we deal with all that. But what you're interested in is a lady comes to you and says, Dad just had a heart attack. I got 3 kids. I need my money back. Typical. Well, what we do in our offerings is we say to that person, if you know someone else who'd like to buy that, you can sell your interest to anyone you want at any price. Generally, they don't know someone. So then they come to you and say, well, Gene, I can't do that. So, okay, here is what I can do for you. I can take your interest and expose it to all the existing members we have and see if any of them would like to buy all or part of it at some price, negotiated between the lady and the members. Remember, I'm not selling the lady's interest. I can only sell securities that I issue. She owns it, so I can't sell her securities, but she can. So we go number 1 to all the existing members, and let's say not all of it sells. Then as a manager, I have the ability to use company funds and make a value decision to buy the rest of it. And then, of course, eliminate those units, cancel those units, and everyone's ownership increases. Or if there's some left, I, as the manager, can buy it myself. Now, there's no requirement. There's no requirement that we're going to be able to solve this lady's problem, but there are enough steps where between her ability to find someone to buy it and bringing it in the company, we usually can solve that. That's never been a huge problem in all my time as a syndicator and in all of our clients. I don't know of any time where anything like that's ever gone to litigation. We can usually solve that, and it's in the syndicator's interest to get it solved so it doesn't go any farther. First of all, the person needs the money, so let's help them out. And number 2, if they don't get it, you're going to get a call from an attorney, and then you're going down the rabbit hole. So you don't want to do that.
You don't want to do that. Okay. So yeah, there's ways that, if a person actually needs to be liquid after the deal is funded, then, there's ways to arrange that, but it just, you might have to jump through a couple of different, hurdles but it's definitely possible. Right. So I want to ask you, what mistakes do you see syndicators, either new or experienced, what mistakes do you see syndicators make besides not hiring an attorney like yourself, or besides going through the documents, the ppm documents themselves, before kind of going through it and sharing it with the possible investor? What mistakes do you see that that mistakes commit that can be avoided?
Yeah, well, you really covered two of them. The ones that irk me the most are when I find people who have tried to draft the documents themselves. And these are legal documents that go in front of an investor, and it outlines an investor's rights and liabilities and remedies. And if you do that yourself, in some states, it's really the unauthorized practice of law. But in the most important issue is, how do you know you're protecting your investors? Are you giving them a document that covers all the things? So that's important. The one that's more irksome is when they do hire me, and then 3 weeks later they call me and ask me a question that I know they would have read. If they'd read the documents, they would have known the answer to. That's good. But other than that, I think a big one is not giving yourself enough time. Most attorneys charge you for this work up front, so a lot of syndicators want to wait as long as they can to put out that money to hire an attorney. In the meantime, they've got money hard in escrow, they're doing their due diligence, they're paying a lender and all that money, but they don't want to start the syndication process, and then they come to me and they have 3 weeks to closing. We can't do that. If you don't get your documents in front of the people 30 days before you need the money, my opinion is they're going to be stressed. They're going to say no. And 30 days is really about the outside. So it would be great if you had a 60-day escrow while you're doing your financing work and while you're finishing up your due diligence. You could come to your attorney and get them started on the documents, because it's going to take an attorney 2 or 3 weeks to draft the documents because they're specific to your deal. Certainly there's some boilerplate, but really the key of the documents, the heart of the documents, is specific to your offering. So not taking enough time is a big mistake. Another mistake is making distributions out of reserves. Some of the offerings on say, we're going to give you a 6% preferred return, and it comes down to the quarter and you've got enough to give them 4, but you've got all this money sitting there for your new air conditioning system, and so you dip into the reserves to make a distribution of 6%. Practically speaking, that's trouble, because you'll never get the money back into your reserve account, and when it's time to do the air conditioning on, you won't be able to do it. Your investors are going to ask you why, and you're going to tell them, well, you took the reserves to send them a check. They really don't want that. They'd rather have the new air conditioning system. Yeah. And secondly, that's fraud. When you say, I'm going to give you a 6% return, and all you're doing is giving them their money back, that's fraud. So that's a big mistake. And I think probably the last one, especially for people who are doing their first couple deals, is delegating the money raising to someone else. In your first couple deals, the people who are going to invest with you, Juan, know you. The reason they're investing is because of you. You need to raise the money. You need to do the investor communication.
Got it. No, those are some great points. So hopefully you guys, were able to keep notes on those. And, if you have to, then go ahead and listen to the podcast again as well. So rewind it and listen to it, because these are some great points that Gene just shared with us. So now on the flip side of that, you mentioned some mistakes. So tell us, some of the best practices that you see that makes your job easier. Some of the things that you like to see. I mean, I guess, you would say, have everything in order, but what would you say is some of the top key habits that you like to see in syndicators and sponsors?
Well, if someone were to hire me after we sign the fee agreement, get ready to go, I'm going to do something that I call a deal structure interview with them. And I do it over the phone. And I have an 8-10 page document that I ask questions about. And some of the things that I find telling my people, here's your homework. You don't have this ready, so get it to me. We need a property package. You know, we need a package. We need pictures. We need sources and uses. We need information about the property. You really need that. If you're going to raise money from an investor, you need to show them what the property is. You know, what every property is different. So if you were going to take the property and put it on the market and try to sell it to one person, you put together a package. Why wouldn't you put together a similar package so you could sell the property a little bit each to 10 people? So that's important. And then we're going to talk about the entities that they're going to form. One of the questions that a sponsor should address is, for the manager LLC, are you going to brand that? When I was doing it, my manager entity was Trowbridge Equity Group. Okay, I used my name. That's what I had to offer. That's what I had to sell, was Gene Trowbridge. So it was Trowbridge Equity Group. And then that became my manager, and I used that manager entity for 16 funds. And every fund started with the word Trowbridge. Maybe it said Trowbridge Main Street, Trowbridge Fund 1, Trowbridge Barstow, whatever, but everything started with Trowbridge. So you should consider whether you want to brand your manager agreement entity so that you tell people you're in the business, because this is the business, you know. Another thing that I think people don't know when they come to me is how they want the splits. I spend a lot of time working through people modeling how much you're going to send to the investors, how much you're going to send here. And sometimes they have thoughts, the clients have thoughts that are way too complicated for the typical investor to understand. Juan, I will tell you that my most sophisticated sponsors, people that have done the most deals with me, generally just simply do 70-30, 80-20 split. They get rid of even a preferred return. Many first-time sponsors put a preferred return in there, and I actually like a preferred return for the marketing purposes. But once you've done a lot of deals and everyone knows you're going to be successful, you don't need to give the investors a preferred return. Those would be three things that I know I spend a lot of time.
No, that's good.
Clients.
Yeah, no, thank you so much for that as well, because, you know, I think to add to that, at the very end, you want to make it as simple as possible. You don't want to, you know, add all these different terms and, you know, have like a waterfall in there and and kind of break it down so many different times, because it's going to be a little confusing for your investors. You know, not everybody knows, you know, how these, are split up and how it works. So, you know, kind of keep it, you know, simple, like you said, you know, 70-30, 80-20, something like that, you know, straight up, and it kind of works a lot easier, right? So,
Juan, the most important thing I can say there is don't use IRR in your waterfall, because many of the investors won't understand what that is. And I have one very good successful client who has a waterfall that goes from on the sale 80-20 to 75-25 to 70-30 to 60-40 and whatever, and it's all based on an IRR. Well, that works for those guys because they're doing 506Cs exclusively with accredited investors who they've had to educate on that, and they understand it. But if you came out today to do your first offering and you're going to go just to people you know and family and friends, that's going to be a roadblock, and people are going to say no if they don't understand it.
Got it. Yep, that makes sense. Okay, Gene, so it is time for our Nuggets of Wealth. These are questions that I ask every guest every week, and hopefully they are able to help out our listeners in one way or another. So what is a good tool, source, or platform that you use frequently that can also help others?
What is a good tool or platform? Well, I think you need a database. That's
Okay.
one of the things if you came to my live seminar, I would say in going out and doing this business, the second thing you need is develop a database. So I use ACT. ACT has worked with me for many, many years. It's one of those things that if you know it works, you always buy the latest version. So
Right.
ACT as a database. Some people use other things, but ACT works totally fine for me. That's a good tool.
Okay, awesome. So act and so have some kind of database to keep track of your investors, and not only all your investors, but it's a lot of team members as well. So definitely have that. What is the ideal time? And I know we kind of covered this earlier, but what is the ideal time for someone to come to you? If they got the property package together, do you think that after they have that together, that is the ideal time? Obviously the sooner the better. Because you want to have enough time for to be able to raise the funds and go through the whole entire process. But what would you say after which a specific event do they come to you?
Most of my clients come to me when the letter of intent is negotiated and signed.
Okay.
And there's a pretty good chance they're going to go into the purchase and sale agreement. So
Mm-hmm.
that's most of the people come at the letter of intent. The second most people come to when they finally have the purchase and sale agreement signed. And I'd like to see that purchase and sale agreement signed with at least 60 days to the close of escrow. And it would be great if there was a provision that you could get an extension. When the market's hot, it's hard to get 90 days. If the market isn't so hot, you can get 90 days from the seller, right? So right now the market's hot in multifamily, so you pretty much need to go 60 days. But one of the things that my firm does that's different than other firms, if you came to me and it was your first deal and you didn't want to get started too fast, but you needed to get started, I would write in my fee agreement that the fee agreement and the money you're paying me upfront covers this deal or some other deal. So you've paid me, we're half the way through the work, you can't get the financing, something comes up in due diligence, you want to walk from the property, we've got half of the work done, that can be moved to the next project. You've already paid me, so your money can just stay there. Then we'll do the next project and pick up where we left off. And most firms won't do that, but our firm does that.
That's very interesting. So that's another added benefit in working with you, that sometimes things don't go as planned, and if you're in this business long enough, then you will surely find that out. So that is an added benefit to be able to do that, because hey, things do get a little pricey to be able to put all these documents together. It gets a little pricey, and especially for those first timers that want to do this for the first or second time. So thank you. Where do you see your business here in the next 5 to 10 years? Gene?
Well, I think it's booming. I think as the economy continues to grow through job formation, specifically multifamily, that's going to mean more households. That's going to mean more demand for residential type real estate, whether it's multifamily or whether it's mobile home parks. A lot of our clients who started in the multifamily building business are gravitating to bringing out mobile home park offerings because they see the mobile home community as an alternative to low-income housing. And I think we're going to continue to go. Jillian and I were just looking since 2014, we've represented over 350 unique sponsors and over 600 unique transactions. So we're cooking, and we've brought in 2 associate attorneys to help our business grow, and I think we'll go. And for those of you who are out there who may have heard this ugly, vicious rumor, I am not retiring anytime soon. Okay?
You still got a lot of years left, huh? You're going to be going strong.
I sure do. And I know some competitors would like to tell people that I'm retiring, but that's not the case.
Yeah, there you go. So for those of you that need some that need some of these documents drafted, then there you go. Talk to Gene. He definitely can help you out. So so yeah, Gene, So where can commit to Wealth Nation go to contact you and find out more about your company?
Sure.
Trowbridge to Doty LLP. Tell us a little bit more where they can contact you.
Well, my email address is gene@crowdfundinglawyers.net. That's crowdfundinglawyers.net. My direct phone number is 949-855-8399. That's 949-855-8399. I'm pretty active on the internet. We have a great website, crowdfundinglawyers.net, but I kind of use my email as a phone. If you email me and tell me you have a question, more than likely I'll jump on the phone and I'll call you, because it's never an easy question to answer just through emails. So you don't have to call me. Send me an email and I'll respond to you. I'd be glad to talk to you. There's never a charge. I don't charge per phone call or by the hour or anything like that.
Got it. Well, that sounds like a plan. I guess one last question, before we jump off, and what do you see the future in this, fundraising platform? What do you see the future of, 506B and 506C?
Right now, there are crowdfunding platforms out there. There are companies that are in the business of gathering accredited investors into their database. And then if you have an offering and you can get your offering on their platform, it's almost like an MLS. Here's a bunch of offerings, and they communicate all those offerings to the database of accredited investors. I think that's going to continue to grow, but I heard an SEC commissioner in the last year say that someday the biggest crowdfunding platform is going to be Facebook.
Wow.
So I wouldn't be surprised, and I've seen it happen already with some smaller offerings, even with people who don't have a track record, because they're never going to get on the big established crowdfunding platforms. They put their own information for a 506C offering on Facebook, and then they try to drive people to that Facebook page, and away we go. And once you have a track record, that'll even be easier. Okay.
Got it.
So I think that's going to be the trend. My only fear is that they make some drastic changes in the definition of accredited investor. There have been all sorts of talks of raising the limits, doubling the dollar amounts, or having a test to test the investor's acumen or IQ before they invest. And
Oh, wow. Yeah.
all we need is a big crash. And then someone will come out and say, well, we need to protect these investors more, and that'll make a big change.
Okay. Well, thank you so much for sharing that as well. It's interesting to know that, he's kind of thinking maybe Facebook will be a big platform for a lot of the crowdfunding, guys. So, thank you so much for that.
LinkedIn would work too, wouldn't it?
Yeah. LinkedIn, Facebook, a lot of these, I don't know about Instagram, they're a little bit different, but, definitely, LinkedIn and a Facebook for sure. So, So Gene, thank you so much for taking the time and, sharing a lot of your experience, a lot of your knowledge, with myself and my listeners. I wish you continued success.
Okay, Juan, thanks a lot. I'll see you the next time I'm in Houston. Okay.
Yeah. Sounds great. I appreciate it. Thank you so much.
Bye.
Bye.